up to me and ask, where is Nancy? We want to get to her lecture. She was a prominent and respected member of the legal community, and she gave selflessly of her time and her expertise to help older adults, both at Senior Law Day and in the community, providing them with current information and informing them of their rights. So we're delighted that Dr. Sills and his daughter, Ronnie Sills Lindbergh, could be joining us today. And we're deeply honored by Dr. Sills and grateful to him for making the lecture possible both in 2003 and still going strong. So it's our great delight and good fortune that we're able to continue the honoring of Nancy's boundless spirit and her dedication to older adults with today's lecture by Professor Kohn. So I'd like to turn the program over now to Mary Scouten, who is the director of the Pro Bono project and a student of mine, to introduce Professor Kohn. Thank you.
Thank you, Rosemary.
Thank you, Professor Bailey. I'd first like to thank everyone for being here today. We are so honored to have such a great turnout. I believe there's about 80 people here, so that's very exciting. And although it's not the event we expected, one silver lining of the pandemic is the opportunity for so many of you to attend an event like this. And with that, I would like to introduce our keynote speaker, Professor Nina Kohn. Nina Kohn is a professor of law and faculty director of online education at Syracuse University College of Law. Professor Kohn developed Syracuse's online program, which was the nation's first fully interactive online JD program, one which I'm sure is booming right now. She is also the Solomon Center Distinguished Scholar in Elder Law at Yale Law School, where she has also served as a visiting professor. Her scholarly research focuses on elder law and the civil rights of older adults and persons with diminished cognitive capacity. Her published work addresses supported and surrogate decision-making, financial exploitation of older adults, discrimination in old age, as well as the potential for an elder rights movement. Most recently, Professor Kohn wrote on the impact of the pandemic on the older adult population, which was published in the Washington Post. Professor Kohn's dedication to teaching law students and serving the aging population is unmatched. We couldn't have hoped for a more fitting presenter to honor Nancy Sills and her family. So please join me in welcoming Professor Kohn.
Well, thank you. Thank you so much. I'm really glad to be here. And is anyone else getting an echo, or is it just me? Everyone else is okay? Thumbs up if it's okay. Great. So thank you, Alicia, for that really, really kind welcome, and Ted and Mary and Rosemary. I wish I could be in person with you, but it's lovely to share this virtual space with you and see so many friendly faces. So today what I'm going to be doing is looking at the field of elder law and aging policy more broadly through a civil rights lens. And I want to make the case for you that all of us, and especially those of us who are lawyers, need to be bringing a civil rights perspective to old age policy and law, and to our interactions with older clients. Now, let me just recognize at the outset that I fully recognize that the claim that we need to focus on aging as a civil rights issue may be met with some skepticism. After all, the conventional wisdom is that older people are a powerful political group. They vote in record numbers. A substantial portion of the federal budget goes toward funding old age entitlement programs. Indeed, older adults are the primary beneficiary of our country's two largest entitlement programs, Social Security and Medicare. And certainly amid COVID-19, older adults are being prioritized for vaccination, in many cases ahead of other essential workers or younger adults with disabilities. So I think it's sometimes easy to assume that older adults as a class of people are not a group whose rights or liberties are under attack, and perhaps to scoff a little bit at the notion that we need to even be talking about elder rights, let alone that we might need the type of elder rights movement that I've advocated for in the past. And yet, as Americans enter and as they progress through older age, increasingly their fundamental civil rights and civil liberties come under attack. And state and private actors are more willing to burden individual liberty when the person whose liberty is being burdened is older. So to see what I mean, I thought we could consider some examples and some context. And we'll start with employment. Now, I probably don't have to tell many of you in this virtual room that older adults face significant discrimination in the employment context. But let me round that out for you a little bit. 1 in 4 workers over the age of 45 report having experienced negative comments about their age in the workplace. The majority of retirees report that their decision to retire was at least in part made against their wishes. And older workers who lose their jobs remain unemployed longer, and if they do return to the paid workforce, tend to be returning to substantially worse positions. So I have a slide here that I want to show you for a moment. And as you can see, this is some data from a social science experiment. And I think Ted's going to share that for us. Looking at how older adults applications are perceived. And it's one of those classic studies in which they submit profiles of applicants to real jobs and see who gets the callback, only changing, one relevant factor, in this case, age. And what you can see from this is that by and large, younger workers are preferred over older ones, and that this preference grows stronger as the applicant grows older for the most part. But what's also particularly notable here is that the effects of age discrimination become particularly acute for women and become acute for women earlier in the life cycle. Thank you, Ted. We can turn that off. So those of you who are lawyers undoubtedly know that the Age Discrimination in Employment Act was designed to address just this type of problem. But here's the thing. Recent court cases make it increasingly ineffectual. Workers bringing disparate treatment claims must prove not merely that their age was a consideration in their firing, but that it was a determinative factor, that it was the straw that broke the camel's back, if you will. And those bringing disparate impact claims increasingly also have an uphill battle, because the Supreme Court has held that policies that systematically disadvantage older adults are perfectly legal, as long as they are based on a reasonable factor other than age. And that's true even if that factor, like higher salary, very closely ties with chronological age. More problematically, we're seeing lower courts beginning to hold that the ADA does not protect job applicants from hiring practices that have a disparate impact on older adults, even if those practices are unreasonable. So for example, the Seventh Circuit considered a claim brought by a 58-year-old attorney who had applied for an in-house counsel job. The job description specified that applicants could have no more than 7 years of relevant experience. So not surprisingly, as a seasoned attorney, he had a lot more experience than that, and he wasn't hired. He brought an ADA claim, and it seemed like a pretty good shot. After all, the notion that you don't want an experienced attorney, that you prefer an inexperienced attorney, appears quite unreasonable. And yet the Seventh Circuit rejected his claim, holding that the ADA simply doesn't protect job applicants from disparate impact based on age. And the case and a series of others coming out like it are really providing a dangerous green light for companies using hiring criteria that systematically weed out older candidates. But to date, the Supreme Court has refused to grant cert on this issue. Okay, let's look at another context in which we see decreased respect for the civil rights of people as they grow older: healthcare. Now, in the healthcare context, older adults are likely to have their treatment wishes less respected than that of younger adults. That is, their treatment wishes are less likely to be treated as binding relative to younger adults. For example, research suggests that controlling for other variables even, older adults are disproportionately likely to be slow-coded. That is, to have healthcare providers choose not to provide them with cardiac resuscitation, even if their wish is to receive cardiac resuscitation, right? To let them die against their wishes. So as the next slide sort of alludes to, In the past, when we were talking about denying care based on age, it was sort of in a theoretical way. It was seen as inflammatory, but not something we'd be doing on a day-to-day basis. Thanks, Ted. But increasingly what we're seeing is that amid COVID, what has been in the past implicit bias or a theoretical question coloring healthcare is becoming official policy in many cases. So when allocating curative care, we're seeing states, we're seeing healthcare systems embracing triage policies that discriminate on the basis of age. So for example, in April, you saw Pennsylvania issuing interim guidance that directed hospitals to prioritize patients on broad categories of life stage, 12 to 40, 41 to 60, 61 to 75, above 75. And those in the earlier categories were to be favored over those in the higher ones. Louisiana similarly has long advised hospitals to employ a triage system for disasters that deprioritizes anyone 65 or older. So let's turn to housing for a minute. When it comes to housing, older adults with chronic conditions too often are facing institutionalization, even when their needs could be met in a more satisfactory way and at a lower cost in a community-based setting. One reason this is happening is that the Medicaid program, which as you know is the primary payer for long-term care services in the US, or at least the primary public payer, creates a pro-institutionalization bias for older adults. And it does this in a couple ways. It, for one, requires states to cover nursing home care for all eligible beneficiaries, but it makes it optional for states to cover most home-based care. And it permits states that do cover home care services to cap the number of beneficiaries who are covered, or the amount of health care they can receive, or the cost of those services. And so what we see is that older adults who need care and who could be cared for safely at home may be forced into institutional-based care instead. And what I think is particularly interesting from a civil rights perspective about this preference for institutionalization for older adults is that it really does stand in pretty sharp contrast to what we're seeing with younger populations. Over the past several decades, there's been a strong push to develop and support alternatives to institutionalization for children and younger adults with disabilities. Orphanages have been shuttered in favor of foster care. Mental hospitals have been closed in favor of community-based treatment. Large institutions for the developmentally and intellectually disabled have been sidelined in favor of smaller group homes or fully integrated settings. And yet institutionalization remains the default for lower income older adults who have chronic care needs. And what concerns me particularly about this push for institutionalization is that we know that nursing home care is far from optimal. And that's not just because most Americans really, really don't want to go to a nursing home. It's also because when we look at what is going on in these institutions, we see that there is a substantial risk to residents of neglect and of inhumane treatment. You know, if we look even before this pandemic, the average nursing home in the United States didn't even have enough staff to avoid systemic neglect. And facilities were routinely failing to comply with federal rules designed to protect patients. 90% had been found to have health deficiencies in their last regular survey. And as COVID-19 has certainly exposed, facilities were often infection tinderboxes. Indeed, about 2/3 of nursing homes were cited for violating rules for preventing infections since 2017 alone. Alas, I don't think the legal system has been the help that we might hope it would be. In fact, in many ways, it's enabled these problems. We see lax enforcement of regulations that are designed to protect residents, including what seems to be a comprehensive regulation, the Nursing Home Reform Act of 1987, sometimes referred to as OBRA 1987, right? But in fact, what you see is that enforcement of these seemingly comprehensive regulatory schemes rarely amounts to more than a slap on the wrist for facilities. When inspectors find that a facility has violated regulations designed to protect residents, states rarely impose a fine. The home is simply directed to correct the situation. States often don't confirm that corrections have been made. And the rare fines that are imposed are typically so small that they're really toothless. Okay, so one last context in which we might see older adults' civil rights and civil liberties at risk. Let's look at domestic and community-based abuse and exploitation. Now, cards on the table, right? People of all ages experience mistreatment, but rates do appear to climb with older age, and especially with age-related disability. About 1 in 10 older adults each year experiences some form of abuse or neglect, and as many as 50% of older adults with dementia do. Many older adults are targeted, moreover, for exploitation because of their age. And indeed, what we've seen amid COVID-19 is a whole flood of new scams targeting older adults around the virus and treatments for the virus. So if you look at this next slide, right, and there's a series of 2 slides here. We'll start with the first one. I just wanted to share with you a little bit of the details on financial exploitation, their consequences. There's some good news and there's some bad news. The good news is that when older adults are targeted for financial scams, they are somewhat less likely than younger adults to actually lose money. But when they do lose money, they tend to lose more of it. So bigger consequences and of course, reduced resilience, right? Less opportunity to earn that money back. So pretty significant consequences there. If we look at the next slide, though, I think it's important to recognize that the consequences aren't just financial. So this is some data from a survey of CPAs looking at the consequences of financial exploitation on their clients. And at least according to the CPAs, and I realize that may be a somewhat biased source, what we're seeing is that the emotional consequences of exploitation can be quite large, even if the financial ones are minimal. And we can talk more about that in Q&A if people want. Okay, thanks, Ted. So what's interesting to me is not just the exploitation itself, but looking at the remedies the law offers in response. And what's problematic is that many of the remedies we offer in the law to respond to abuse and exploitation are themselves coming at the cost of the rights and dignity of older adults, the very people they're designed to protect. So for example, in many states, third parties are required to report abuse of an older adult to the state, even if the underlying information and relationship is confidential, and even if that older adult is fully competent. And sometimes, even if the abuse is not a wrong by another party, but what we would call self-neglect. And this type of mandatory reporting scheme can have the effect of denying older adults the right to engage in confidential communications with their doctors, with their nurses, with their priests, their rabbis, even their spouses. And the effect is that an individual's right to privacy, and even to the most confidential, intimate relationships, privacy in those relationships, becomes curtailed, I've argued unconstitutionally in some cases, simply because the individual has experienced their 60th birthday or their 65th birthday. So similarly, in the name of combating sexual abuse, some states are criminalizing certain forms of consensual sexual conduct if it involves an older adult. So for example, if you're in Washington state, it's a crime for a disabled person who's 60 or older to engage in consensual sexual activity if that consensual sexual activity is with someone who provides them with paid transportation. So likewise, we're seeing that in an effort to combat financial exploitation and undue influence, states are increasingly criminalizing certain financial transactions that are with an older adult in situations in which the alleged victim may actually approve of that transaction and have otherwise provided valid consent to it. And perhaps most problematically, of course, we see that elder abuse victims who have suspect cognitive capacity may find themselves getting involved in the APS system and sort of railroaded into the guardianship system where they may be subjected to a full guardianship that strips them of the right to make even the most basic decisions about their own lives or their own bodies, even if less restrictive alternatives, decision-making support, limited guardianship, single transaction orders, and the like are technically available under the law. Okay, so let me stop there because I could go on and on like this, right? I could be listing the civil rights problems that older adults experience and how the law does or does not respond. But I hope that the illustrations to this point have served to show this, that older adults experience distinct disadvantages when it comes to their civil rights, and that these disadvantages are shaped by the law, by legal rules, and by how we enforce those rules, or in some cases, how we choose not to enforce those rules. Now, since most of us here today are lawyers or about to be lawyers, in the case of the students, I thought we should look at the role lawyers have in all of this. And I want to suggest to you 3 roles for lawyers. First, and I'll sort of build on these in a minute. First, as lawyers, we can use the law to help challenge the status quo and the mechanisms of what we might call structural ageism, policies and programs that systematically create and compound disadvantage for older adults. Second, we could use our skills to raise awareness and encourage the type of rights consciousness that can be a tool for advocacy. And third, and we can practice law in a way that is sensitive to the rights of older adults and empowers our older clients. So let me address each of these in turn. First, as lawyers, we have this very cool, unique ability to use the law to challenge the status quo and systems of disadvantage. But unfortunately, what we see is that the problems I've just shared with you have proliferated largely without legal challenge. So for example, the mandatory reporting statutes that I was discussing, such as those that require clergy to report on their parishioners, have pretty profound implications for basic civil rights and civil liberties. But the legal permissibility of these statutes has yet to be challenged in a court. By comparison, if you look at child abuse reporting statutes, they've been subject to lots of legal challenges, even though, right, as a constitutional matter, they require far less justification than ones that abridge the rights of older adults. Similarly, if you look at the triage standards that states and healthcare systems are using that are denying life-saving treatment to older adults, we've seen advocates for older adults certainly critiquing them, writing letters of complaint to government officials, but court cases have yet to be filed. By comparison, if we look at what's happening in the disability rights advocacy space, there's been substantial and very vigorous efforts in challenging provisions that would deny care on the basis of disability. The failure to challenge these policies that selectively undermine civil rights and civil liberties of older adults is, in my mind, though, not just a missed opportunity. I think it's itself dangerous because the silence of the legal community creates an impression that age discrimination, that ageist policies, that ageist structures are simply not legally problematic. And I think it sends a powerful signal to our policymakers that they can adopt this kind of policy without any real concern about pushback. And the longer we go without challenges, the more acceptable such practices become. So for those of you in this virtual space who are in a position to challenge laws and policies and practices that unreasonably burden older adults' civil rights, let me say this, please do. It's time. It's time that we invest in the type of litigation, impact litigation in this space that we've seen in the disability rights space. And the field is far from crowded. Only a handful of organizations are engaged in pursuing impact litigation on behalf of older adults. And the scope of that litigation to date is pretty limited. It primarily focuses on access to benefits. So there's a real unrealized opportunity and need here. But attorneys are also really well positioned to provide some much needed advocacy without litigation, right? Advocacy in the legislative and in the regulatory space. Without that kind of vigorous advocacy, though, the status quo is likely to prevail even when policymakers are actually open to change. So I realize we're not all together in one room, but a quick show of hands. How many of you have heard of the Protecting Older Workers Against Discrimination Act? Ooh, I'm scrolling through. Okay, I have 1, 2, fantastic. That's pretty unusual. So this is an act that's actually passed the House last year, and it would make it substantially easier for older adults to bring age discrimination claims. For those of you who want to be wonky, what it would do is it would essentially reverse the Supreme Court's decision in Gross versus FBL Financial Service Workers, which raised the proof requirement for plaintiffs. Now, it had bipartisan support in the Senate, but it never went anywhere. It languished despite that bipartisan support. But that's to be expected, I think, when you don't have vigorous advocacy pushing for this type thing, when you don't have a really energized constituency to push. And I think COVID-19 has also really exposed for us that we really do need much stronger advocacy on behalf of older adults, and especially frail older adults. Let me give you one concrete example. As many of you know, both the federal government and the states have responded to dangerous conditions inside nursing homes amid the pandemic by barring visitors from the facilities. Now, I think that seems like pretty sensible practice at first blush. I mean, certainly we know that residents are really high risk from infection. About 25% of all confirmed COVID deaths in the US are of nursing home residents. But what has this approach meant? Well, it's meant that nursing home residents are kept under conditions that are really akin to solitary confinement, where their only interaction is with a flow of staff who arrive and leave with particular tasks in mind. It's meant being denied contact with family, even if that family was willing and able to take all reasonable precautions, testing, PPE, you name it. And it's even meant being denied access to family who were serving as caregivers, providing the type of wraparound care that residents needed given the systemic understaffing in many nursing homes. And yet this ban has been accepted in the name of protection, even as states refuse to take the real measures needed to reduce flow of COVID-19 into these facilities. So there's a great study out that indicates nearly half, about 44% of nursing home cases of COVID are attributable to staff working in multiple facilities, bringing it from one facility to the next. Yet not a single state adopted a one-site rule as provinces in Canada did. Nor did regulators require or even incentivize facilities to take efforts to reduce reliance on part-time staff and the use of staffing agency personnel, even as billions, $21+ billion in additional funds were pushed out to facilities. I think this kind of casual tolerance of unnecessary and pointless suffering and isolation of older adults shows us just how weak advocacy for frail older adults is. We simply don't yet have the type of robust advocacy that is needed to protect against even such casual and unnecessary cruelty. And let me suggest to you that perhaps lawyers could play a significant role in filling this advocacy gap. Okay, second role for attorneys. I told you I had 3. The second role for attorneys, I think, is quite pivotal. Oh goodness. Look, many of us are not in a space to bring impact litigation and may not have an appetite for legislative reform. But we can still do a tremendous amount by using our skills and our legal knowledge to raise awareness and to encourage rights consciousness. This may sound a little bit simplistic, but I think it's actually really important because there's currently a widespread failure to recognize the civil rights incursions that older adults are experiencing as civil rights problems. And as a society, we're really not in much of a position to fix things that we can't see, right? So lawyers have a unique ability to help the public see and fix these issues, because we as lawyers have the tools to identify and the language to describe civil rights problems. And by using the language of rights to describe the indignities that older adults face, the invasions they experience, we can help make civil rights concerns visible and tangible. And I don't think I have to tell any of you that the language of rights can be a powerful tool for law reform. So let me just give you one good example of this, and we'll look north for it. In 2001, the Ontario Human Rights Commission published a report detailing the ways in which the province's legal system engaged in age discrimination. And it labeled that discrimination as a civil rights issue akin to discrimination on the basis of race, sex, or disability. That report became a powerful catalyst for legal reform, in large part because that rights-based language was really salient to the media, and it brought a good deal of media attention to issues of age discrimination and mandatory retirement policies then in play in Ontario. And so you saw this proliferation of news stories and editorials saying that mandatory retirement was discrimination, it was a deprivation of older adults' rights, and this led to a bipartisan embrace of legislation revising the Human Rights Code for the province and outlawing mandatory retirement. And I think in the US, we could see that same framing having a similar effect in other arenas. Certainly throughout our history as a country and consistent with our liberal tradition, rights in our political discourse function as trump cards often in a way that mere values or considerations do not. Okay, finally, the third role, and perhaps in some ways the most important for many of us. A third role for lawyers, and especially for the elder law bar, is to bring a civil rights lens to the everyday practice of law, to represent older adults, whether it be in an elder law practice or in another context, in a way that is conscious of their rights and sensitive to the civil rights implications of various legal tools or techniques we employ. So thinking about how we do the activities we already do. Let me just consider for a moment what this might mean for an elder law focused practice. So the next slide shows you some of the common things that elder law attorneys do, right? Elder law is typically described as a practice that focuses on planning for later in life needs through individual client counseling, through document drafting. But when Ned Spurgeon and I surveyed elder law attorneys across the country, what we found is a real wide variety of tasks that elder law attorneys were doing. And I think if you look at the array of topics that elder law attorneys are covering, what you see is that many have pretty significant implications for older adults, civil rights, and their civil liberties. Thanks, Ted. So let's take, for example, helping clients prepare for long-term care needs and structuring their finances in a way that is advantageous for that. A good rights-aware counsel in this area can really help older adults increase the control over their health care, over their future, their living arrangements, their resources. But such planning can sometimes have the opposite effect, right? And we may see attorneys who are not sensitive to the impact on a client's rights and liberties, inadvertently helping their clients structure their finances to maximize eligibility for benefits or reduce taxes in a way that actually doesn't meet the bigger goal of helping them control their life and life decisions. And so setting aside even the risk of exploitation that comes from turning over control finances, this can have a really deleterious effect on clients' perceived sense of control and their emotional well-being. So by looking at the practice of elder law through a civil rights lens, I think elder law attorneys can increase the likelihood that they will consider and address and be sensitive to the civil rights implications of what they do in their everyday practice. And in that way, they can really be part of the solution to ageism, or at least counterbalance to ageism, and not part of the problem. Okay, let me conclude with just a few thoughts. I think as a society, we tolerate removing rights and opportunities from older adults that we just wouldn't tolerate removing from younger ones. And I think it's time that we acknowledge this and that we appreciate the toll that it takes on the physical and psychological well-being of older adults, and maybe of younger adults too, because it makes the prospect of growing older scary for all of us. And the increased dread that comes with gray hairs and birthdays is perhaps somewhat avoidable if we actually look at how we're treating older adults as a society. By embracing a civil rights approach to aging, I think we can create a more balanced approach and recognize that, just as with younger adults, older adults' rights should not be undermined or denied unless there's a really significant justification for doing that. So we need to be less casual about that. If nothing else, I hope that today's conversation has helped you see some value in using a civil rights lens to examine the field of elder law and the laws and policies affecting older adults more broadly. And I really hope that each of you will consider bringing that lens, and many of you I know already do, to your work with older adults, whether it be by using the court system to challenge the mechanisms of structural ageism, whether it be by helping create awareness of civil rights issues with older adults and how the law can either enhance or undermine that, or whether it be by using that lens to inform your daily practice of elder law. So I'm going to end there, and I understand that there is some opportunity for Q&A, so I will turn that over to the rest of the team.
Thank you, Nina.
Thank you.
So first, I think we are going to show the code for the CLE, Jeff, if you don't mind. So if any attorneys are present and you want to get the CLE credit, there's a code available. And then after that, we'll open up for Q&A. Okay, yep, so it's just Sills 2021 for the CLE code. And if you have any questions afterwards, you can always reach out to us with the CLE forms. So we'll just leave that up for a little bit. And then if anyone has any questions, you can feel free to either go ahead and ask or type in the chat.
And I'm happy to look at your hands waving or your little electronic blue hands, whatever people like. Kevin? Nice
Hi,
to see
Nina. Nice to see you. Great presentation. And thank you to the sponsors of this memorial lecture. Really important topic, not talked enough about. And I love that Albany and Nina are leading the way. Nina, as I emailed you, there's an upcoming Netflix film about an evil guardian who, here you go, who, abuses and robs older folks. And she's a attractive attorney who's apparently very charming and uses this to rob folks. It's supposed to be very good. It was well reviewed. It's got some great actors in it. It maybe poses some opportunities for us to get more attention to these issues and problems of elder abuse and exploitation and bad uses of guardianship. I suppose it also poses some risks to, stigmatize anyone trying to help older folks and legal remedies for doing that. I'd be curious on your instincts about what, how we could mitigate the risks and make use of the opportunities. And frankly, whether it's even realistic to think that, we amongst us have the capacity to influence a national conversation, should there be one about this Netflix film, which may be good, but maybe a drop in the bucket of all the content that's out there?
I think that's such a great question, Kevin. It's certainly a question that's near and dear to my heart. There's others on this call, and I'm looking at you, Rosemary, too, who I think might have some really interesting answers to that question. I'll just give it my shot and invite others to chime in. I think there's been a lot of stories in the popular media in the past 2-3 years looking at guardianship abuses. We can think about the series that came out about Nevada. There's some really damning stuff out of Florida. The New Yorker spread that Rachel did. And part of the problem there is that talking about abuse is sexy. Talking about line by line statutory reform, not so sexy. And indeed, despite my best efforts, none of that got into the New Yorker story. We can talk about that later. But I think, as lawyers, we need to be acknowledging the problems, but also acknowledging the value of these systems and what can be done about them. And getting beyond the good, bad argument to say, yes, there's bad. The type of scenario that, to the best of our knowledge, will be portrayed in the Netflix special is an anomaly. It is not the norm, but here are all the things we can do, and here are all the things states are doing to make sure it doesn't happen. And if this pisses you off, here is what you can do about it. And I think that's where we've fallen down, is the here's what you can do about it part. The call to action is typically not part of the advocacy efforts. And you certainly, if you compare what's going on in elder advocacy versus disability advocates have been very good. It is always including a call to action. But part of the problem I think we have in elder advocacy is that we don't have the same sense of identity and community, right? We spend the bulk of our lives living with older people being the other. And then we're somehow supposed to magically embrace that identity of being an older adult after, decades and decades of othering older adults. And it doesn't work. It's not our primary identity. So I think part of the reason to talk about these rights invasions is to help older adults, for one, see the real risks that are being placed on them because of that identity, so that perhaps you can get a little bit of identity politics here. But that's my long-winded way of saying I think things need to be accompanied by calls to action in really concrete ways people can do them. And Rosemary, I saw that you're unmuted. Did you want to jump in, or Lewis?
I just did want to add that I think it's consistent with your comments about civil rights, that a lot of people view older adults as invisible, and that really it's someone else always speaking for them. And I even found myself, and Mary can talk about it, I think even in elder law, I fell into that trap myself. But if you see ads on television where they're talking about where your mother's going to live, it's not about the mother, it's about the daughter's decision. And I think there's more and more of that goes right along with what you've been saying about civil rights.
And that notion of nursing home placement, I wish we could get rid of that word, placement,
right.
Like trying to figure out where to put a dish in your cupboard. Lewis, was that a hand?
Yeah, I have a comment and a question. I have a good friend who, at the age of 81, he's an attorney, was told by his law firm that he was going to retire. And he wasn't quite ready to retire. And he called me up and he said, what can we do about this? And I said, well, why don't you come work with me? So his name is Peter Strauss. And I've been working with Peter for the last 3 years. He's 84 years old now. He's as vibrant now as when the day I met him 25 years ago. And he's just been a phenomenal advocate for seniors. And he works in does guardianship at New York Law School, runs a clinic there. So my question is this: equal access to justice is an issue for a lot of groups. Why isn't it an issue for seniors? The court systems are so hostile to seniors. We do a lot of guardianship work. We do a lot of guardianship trials. And the guardianship courts, at least in New York where we practice, are not built for a senior. I've done guardianship hearings at a calendar call where there were 50 lawyers in the courtroom and I had my clients up at the bench. And we were asked to just present our cases in front of the entire courtroom, seeking a guardianship over an aging individual. How do we get the courts to recognize this need? The guardianship statute in New York is wonderful. If we had judges, and there are some that are phenomenal, that have written very scholarly decisions, but they put the cases on the wheel and it goes to a random judge who knows nothing about the guardianship statute or guardianship, and you appear with your family in that kind of an environment. How do we get the courts to kind of catch up to what we're trying to do here?
I think that's a great question, and others in the room may have other ideas. I'll give it a stab. I think one is education for judges. I mean, we've seen this parallel issue in the medical context where you don't have good geriatric care if you never educate physicians about caring for older adults, and you think that, you know, your general how do you treat problem X without how do you treat problem X with comorbidities and advanced age is going to give you good care. It doesn't in medicine, it doesn't in law. I do think in the guardianship area, we also need to be focusing on how to make it harder for judges to do the wrong thing, right? So for a long time in guardianship, we keep trying to come up with better rules and better, you know, things to tell judges to do. And I think actually what we need to do increasingly is to put speed bumps in their way, to make it more painful for judges to do the wrong thing, right? If you want to do this, you have to do X, Y, and Z too. Because I think just changing the rules and not the incentives is not going to do the trick. And so I'm hoping that in successive waves of guardianship reform, and it's frankly a large part of what I tried to do as the reporter for the new Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act. Terrible name. Is what we tried to do with that is try to focus on systems-based approaches and incentives, see how well it works. But I think some of what we have in there might help.
Thank you.
Other thoughts or comments?
I do have two questions in the chat. Oh, Mr. Sills, you can go first. Dr. Sills.
Just an observation here in Florida, the governor has approved vaccinations for people, the essential workers, as well as people 65 and over. And the 65 to 75 people are being attacked by the older people, 75 and older, feeling that they deserve the primary treatment over the younger, older group. It's just an interesting thing that's happening down here. And
Yes,
letters to the editor from the older group are expressing their dissatisfaction that it's including people from 65 to 75. Just an observation.
How often do we actually get arguments about whose life is more worthwhile? I mean, it's been fascinating and horrible. One of my pet peeves too, though, is we often see this discussion of essential workers or older adults, ignoring the fact that increasingly many people are working, including in service-related jobs, well into older age, and ignoring that dimension of it. But I see a comment in the chat, which was any suggestions about how to get nursing homes or similar facilities to really do their job and take care of vulnerable people. Oh, well, this is fun. Well, we could start by repealing the grant of immunity. New York's being one of the broadest and most utterly egregious and indefensible in the country, because we've essentially given facilities a green light to not do any of the things they're regulatorily required to do. Then I think we need to ramp up in enforcement and really create the incentive to do the things that we want facilities to do. And if you think that that's unfair to facilities, then I guess I would have two responses. If you don't really care about facilities doing it, don't make it a rule. Figure out those things that are really important for facilities to do and enforce those. And the problem is, I think under our current system of enforcement, you see more enforcement of the things that are less important. The real quality of care issues are the ones that tend not to be enforced. Whereas, you know, a facility issue, which is likely to have less of a direct consequence, is easier to enforce. So I think we need to move back to per day fines, not per instance fines. And we need to be confirming that corrections are made. Ultimately, though, I think that, you know, we're definitely seeing this amid COVID-19, is that the single biggest predictor of quality of care is staffing levels, and particularly nurse staffing levels. And it is high time to be putting in some minimums, especially if we're not going to enforce our outcomes-based measures, quality of care, then we need to be requiring certain inputs, staffing. You could also imagine going to a medical loss ratio model where, much as the ACA has done for health insurers, you require a certain percentage of funding that nursing homes are being given to go directly to patient care. And certainly if we look at what's happening with the for-profit facilities, which make up 70% of this industry, you know, even as care is tanking, we are seeing a continued and sustained interest from the financial sector in purchasing these facilities, which suggests, as we've long known, that profit is being made at the expense of patients. And so a medical loss ratio approach might be one way there. That's probably more than you wanted. So a question was given about any suggestions how we can increase geriatric education for lawyers and for physicians. I think one way is, you know, honestly, Albany Laws is setting the standard here, right? You're pushing out free education. And if you make things free, right, people are more likely to come. You know, it's the old equivalent of cheese and dip and wine. But I think there is tremendous opportunity for people who care about this education, especially in a space in which we can reach people anywhere in the country right now, to be putting out education, especially if it meets a need. You know, when I'm doing elder law education, I usually try to make it qualify for ethics credits because that's what people actually need. And I think also cross education is really important, interdisciplinary education. And Izzy Doran and Maria Brown and I put out an article in that in the Elder Law Journal a couple of years ago, looking at some ways to do that. But I really encourage those of you who are in the education space to use case examples with older adults to teach topics that you might not think of as elder law, to give it that opportunity, and to insert modules about aging into other classes as well. So you don't have to just have an age-specific course or education to be covering these issues. Mary, did I miss any?
Yep. So I think two people asked if you know if the Biden administration has any plans to address elder law issues.
I am probably not the right person to answer that. You know, certainly the care, Biden's proposals around caregiving and family leave would be a massive boon, I think, in this space. You know, increasingly, you know, well, not increasingly, but we rely on family members, and disproportionately women, to provide the bulk of elder care in this country, right? And yet people don't have leave from their jobs. They do that at the risk of their jobs. And as we saw, when they take time off and out of the workforce, they increasingly have trouble getting back in. So I think proposals there to strengthen leave policies and paid leave will do a lot of good. You know, and maybe this is unnecessary, but I do think, you know, we've seen what used to be sort of separate in the federal government, you know, aging policy and disability being combined into ACL. And I do worry that the result of that is that you really have the disability part taking over and the aging rights sort of falling by the wayside or being an afterthought tacked on. I think there's some really great people going into ACL right now, but I am concerned that we will continue to see that as sort of aging being sort of the lonely stepchild of the administration. But then I'm not a glass half full person sometimes. I realize that. That's what happens when you start your career doing elder abuse and neglect. It just does weird things to you.
Okay, we have one more question in the chat, and then if anyone else has any further questions, but I know we're sort of running out of time. The last question in the chat is, what are some ways legal or non-legal new attorneys can get involved in their communities to further support the older adult population?
Well, I mean, I think that we really ultimately need to be building a grassroots movement for this. And that can start almost anywhere. But thinking about, what is something in your community that can be different, and working at the community level can make a big difference. Right? I think right now we're seeing some interest in agitating around the visitor bans in long-term care. And I think that energy could be used to be expanded. The problem is that I think, the question is, what is the ask and what is the technique for that? And just pure anger without a technique often doesn't get us very far. Lisa?
My apologies. It was an error. I asked my question already. Thank you.
Thank you. And thank you, Ronnie. That means a lot.
Any other questions?
Well, then I will just say thank you so much for the opportunity to be here with you all today. I am terribly flattered to have this opportunity and to be able to do this memorial for Nancy Sills and to work with all the great people at Albany. My very first conference as a baby law professor, I was on a panel with Dean Ouellette. And this is a wonderful time to get to be on a virtual panel with her again. So thank you very much. I'd welcome people to continue this conversation over email or in any other way. And you can find me online. I'm at nakohn@syr.edu.
Thank you so much, Professor Kohn. It was such a great event. And thank you again to the Sills family for being here and for giving us the opportunity to have this event every year.
Yes, thank you very much. Thanks, Nina. Thanks, Dr. Sills.
Oh,
Thank you,
Ronnie.
Ronnie.
Rosemary and Nina. Thank you.